Hello friends, Namaskar. You are welcome to this show, Dr. G.K. Goswami IPS. You shall be happy to know that this live series, it is 25th. So we are celebrating the Silver Jubilee for this program. And in this program, today we are going to discuss constitutionalism. Many of you, being the candidate of legal field, must be aware of it, but those who do not have the background of legal studies, let me just explain the constitutionalism. Basically, constitution is a statute or a textbook of legal laws and other things. But how that get into translate into ground reality, that is constitutionalism. We will explain in more detail, but just to introduce the topic, I thought that I must explain in brief so that those participants who are not from the legal background should also enjoy this live discussion. Thank you very much for joining us and be with us. I will try to conclude it in around 1 hour or so. So be with us and enjoy it. So constitutionalism, a global perspective or global overview. As you are aware that in most of our discussion, we are discussing not only in Indian context, but in majority of the jurisdiction, various aspects which we have discussed earlier. Here again, we shall be discussing this topic in context of India, US, UK, South Africa, and many more jurisdictions like Germany, Australia, and so on and so forth. So, before we enter into this domain, let us understand the difference between constitution and constitutionalism. So, as you know, that consider that this is our body. To understand it in a very simplest manner, so constitution, my dear friends, is like our body, and constitutionalism per se is like our soul. So constitution is a visible aspect which can be understood in a very tangible manner, but constitutionalism is like soul. It is intangible. It is not visible, but it is essence of the constitution. So without constitutionalism, constitution itself is not functional. So functional aspect of constitution is constitutionalism. So understand the theory of body and soul. Constitution is body and constitutionalism soul. So first of all, understand the various aspects of constitutionalism. So constitutionalism is a political and legal philosophy. So constitution per se is a legal phenomena. Any constitutional assembly like in India or parliament or the law-making body, they actually formulate or promulgate constitution. But it is the political will or it is the political phenomena by which constitution gets implemented, and that implementation itself is constitutionalism. So in simple terms, if I say legal philosophy behind constitution is law-making, but political philosophy, it is the political will, how constitution gets implemented is constitutionalism. The key principles dealing with constitutionalism are the limited power of governing political identity. Otherwise, my dear friends, if there is no control over the government, then the government becomes untamed. There is no limit of their power. So limit of the government is very, very essential so that there should be no tyranny of governance. So that is very important. There should be no arbitration, arbitrariness. The accountability of the government. Actually, constitutionalism brings accountability of the government and the accountability towards we the people, like in India. We the people are the real source of power. They actually make or break the government. So it is we the people of India, or like any other country for that matter, the society, the public is the power game. Then Constitutionalism ensure rule of law, the supremacy of law. And supremacy of law, if you remember, it can attribute it to 1215 Magna Carta in UK, by which the king was made subservient to law. That means the law is supreme, and any constitution is supreme law, and that is called, in terms of Kelson's pure theory, Garud norm. Garud norm is the supreme law of the country. Like in our country, we have adopted Indian Constitution of 1950 precisely on 26th January of 1950. So that is Garud norm of our country. It basically provides judicial review power, and that is very, very essential, that who will govern the government. So it is constitutionalism which govern the governance, which govern the government by way of judicial review. Understand that judiciary is the custodian of constitution, the supreme law. So the role of judicial review is very, very critical, and that is also essential part of constitutionalism. In many jurisdictions, we will see that powerful government has always tried to control the judicial review power of judiciary. But how it had happened, we will tell you in our discussion, like in case of Anand Bharti and many other cases, how the basic structure doctrine was formulated in India, and many such great contribution in constitutionalism different countries over the period of time have been made. That is really very fascinating and good to understand the nuances of constitutionalism. Now the core feature. Many things we have discussed, but let me just narrate it in a very systematic and precise, concise manner. Basically, constitutionalism ensure check and balance of power. You know, the government has three organs, my dear friends. One is the legislature, the lawmaking body. The another one is executive, who follow the orders of the law or the government to some extent. And then the third is the judiciary, who adjudicate and also interpret the law. And in common law country, they also make the law. The judiciary made law. That is the precedent. And this is the beauty of common law country. India, UK, US, they are all common law country. Understand, common law country are those countries where precedent are used as law by the lower court. Then protection of fundamental right. Virtually speaking, the government is made for bringing happiness in the society. And protection of fundamental right, particularly the body and property of the people, the liberty of the people, freedom of the people are very, very important, and constitutionalism ensure that government do not abridge such important rights of the people. Then comes the judicial independence. As I mentioned, the judicial review is the core of constitutionalism. But if judiciary itself is not independent, particularly in their functionality, then how judicial review will be looking at the good law or bad law, or whether the constitutionalism is implemented or observed in true spirit. That is why the independence of judiciary is very, very critical in democratic setup. Then comes the popular sovereignty, right? Sovereignty is the hallmark of any independent country. The independence in terms of sovereignty. Sovereignty means to take decision independently. There is nobody to impose any direction on any, or any, imposition on any, in any sense to the country. That is sovereignty. Why constitutionalism is relevant? It prevents tyranny of the rulers and majoritarian. Then it protects rights, as I mentioned, especially the minority, dissenters, and vulnerable section of society like females, the children, the physically challenged people, the marginalized people, and so on and so forth. So there are vulnerable group of people. Then enable democracy. They create democratic environment, ecosystem, particularly the various organs of the governance, various departments, various system like election commissions, anti-corruption regime, various other domain. Then comes the support of good governance, promote stability, ensure maintenance of law and order to bring peace and tranquility in the society. So overall purpose of constitutionalism is how best you implement your constitution. That is the essence of constitutionalism. Now, as I already say, and most of the time we used to do, we give you metrics. So let us see the difference between constitution and constitutionalism in a metrics format. So there are aspects like definition. Constitution is a written document. Sometimes it may not be. Most of the country has written document like in India, UK, South Africa, Germany, Australia, and so on and so forth. But the most important country is the United Kingdom. There, till date, there is no written constitution. But the spirit, the precedents, the traditions are very, very important. And you will surprise that why common law country has the tradition to obey precedents? Because they are in United Kingdom, which is the mother of common law country. There is no written constitution. When there is no written constitution, then traditions, the precedents become very, very important to follow, and that is why common law country follow the precedents. On the other side, constitutionalism is a broader philosophy. It is intangible part of the constitution. It is the implementable part. It is a living commitment, and especially the political will to practice that ensure the government acts within limits and respect the rights, and it is limited governance. It is not unlimited, untamed power. So there is no tyranny, there is no discrimination, there is no misuse of power, and that is the role of constitutionalism. Then what is the focus? Focus in the Constitution remains on the text, on its language, on its texture, on its how meticulously Constitution is designed. It is very, very important. Otherwise, if the language, the text, and the syntax of Constitution is not properly designed, then it may be misinterpreted. It may be misleading, interpretation. However, the Constitution is the implementation part. How best you implement it. What is your inner conscience? How you are committed to implement in righteous spirit. That is constitutionalism. Then possible without each other. A country may have a constitution without true constitutionalism. There is same constitution in dictatorship. So there are various countries even in the existing system that there is a very well written constitution, but because of lack of political will, constitution is missing, and that is why it is like a hollow system of constitution. That is important. But constitution cannot exist without genuine limits. Constitution is directly linked to limit the power of the government, but in a very systematic manner for a specific purpose. And then the example, if you say the Soviet Union had a detailed constitution but no true constitution under Stalin period. There may be so many other countries, and there may be in the modern era also, which may not be following constitutionalism in a true spirit, but they may be having very detailed and very descriptive constitution. So merely having constitution does not serve the purpose until unless the government is committed to observe constitutionalism in true spirit. Now you see few case laws, although we will talk separately, but just to give a snapshot in the beginning itself in the introductory part. So in India, case 1 on Bharti in 1973 and Minervaville case, although we will give you a series of cases, how the jurisprudence developed in India about the constitutionalism, but these two cases are the backbone of constitutionalism and various other doctrine, and it provide you the basic structure principle, which is the innovative idea of Indian judiciary to the globe. This is the best, you can say, the contribution to the global jurisprudence by Indian superior judiciary. Then comes United Kingdom. There are two cases filed by Miller. So this I am talking about the Miller two cases where executive accountability to Parliament was established and rule of law was also talked about. Then in USA, US versus Nixon, this is a very interesting case, we will discuss in detail, where Nixon refused to hand over the documents or the details of Waterloo case. And then Supreme Court intervened. They say that you are not above the law. And we will discuss in the next 5 minutes. Then South Africa, this is important case, treatment against action campaign. It is basically HIV related matters. We will discuss in detail. In Australia Community Party case, this case is also very interesting. The ruling party at that point of time, they passed an enactment in the court of in the parliament saying that we are abandoning or we are scrapping Communist Party, but the Supreme Court or the apex court intervened and they say this is unlawful. So that is also important to know. Then global status. Now friends, with this background, now we will enter into case by case, that is jurisdiction by jurisdiction. So as usual, it is important to know what happened in United States because various cases and various incidents actually brace constitutionalism over the period of time. And you must be aware that US Constitution was implemented from 1789 and therefrom the constitutionalism has taken shape in a different manner. In 1803 there was very important case, we will discuss it right back. And that case is basically Marbury versus Madison. Very interesting case of 1803. The students of masters in legal studies, that is LLM, or even the LLB student, those who are preparing for civil service, the judiciary and many more, this case is Bible for them. I request you this case is most significant case on constitutionalism in the United States and it largely impacted global democracies. How it impacted, we will talk. The citation is written here. The fact of this case goes like this, that in 1801 the ongoing president, John Adams, appointed several federal judges. Federal judges means in the Federal Supreme Court of America. When the president was outgoing, almost on that night itself, several judges were appointed to serve their political purpose. One among them was William Marbury, who is the petitioner in this case, who was midnight appointed judge. The very next day, the new president sworn in, and he was Thomas Jefferson, and his secretary James Madison refused to deliver commission to Marbury. Marbury, when he did not get the commission, it means that commission means the appointment letter actually. So Marbury preferred to go for writ of mandamus. You must be aware writ of mandamus is by the superior authority or by the court to give order to the concerned authority to perform his official duty. And here Marbury requested the Supreme Court to direct Madison to issue the commission for his appointment. That was the writ. The key issue was, could the US Supreme Court issue a writ of mandamus to Madison under Judiciary Act of 1789? The ruling was the Justice John Marshall. Marshall is a very, very renowned and great jurist of his time. He directed that Marbury has the right to get commission because when he was appointed, John was the president. So whether it was the order or the appointment done with malicious intention or not, but he was having authority to appoint him at that point of time till he was stepped down. Madison's refusal to issue commission was illegal. So the writ of mandamus was accepted by saying or by ordering Madison to issue commission to newly appointed Judge Marbury. The part of Judiciary Act 1789 giving the power to Supreme Court to issue writ of mandamus in such situation was illegal. So one can discuss whether the appointment was right or wrong, whether with good intention, bad intention, but the court here decided that it was within the limit of the power of the outgoing president. When he was appointed, the president was in his place, he was having that capacity, and hence the writ of mandamus was issued to commission Marbury. The Chief Justice Marshall, what he said, quote, "It is emphatically the province and duty of the judicial department to say what the law is." That means it is the interpretation by the court. It is the duty actually. And it is the duty of the Supreme Court or the apex court for judicial review to know what the law is and how it has been implemented. So this actually brought constitutionalism in place. This is the beauty of this case. The implication of this case, it implies that if law conflict with the Constitution, the court have the power and duty to declare it void. It create or it is the genesis of judicial review. So my dear friends, especially the candidates of graduation, post-graduation or any competitive exam, they should know that this case is also to greater extent is the genesis of judicial review. It actually grounded judicial review into legal platform. Without power of judicial review, any law could override constitutional right. This is the beauty of constitutionalism. And here from the judicial review became the integral part of constitutionalism. Judicial review is very, very important. Otherwise, who will decide what is right law and which is not? So constitutionalism is making constitutionalism hollow. That means the core idea of constitutionalism is making Constitution perfectly implemented. Now the implication of this case, it has still very relevance in the modern and contextual manner. Judicial review become fundamental right like in India, South Africa, Germany, even in US also. It anchored the idea of limited government. Constitutionalism actually, if you see the entire case of medicine, it actually limits the power of the government. Arbitrariness was also dealt with. It is the supremacy of the Constitution. So supremacy of law means supremacy of Constitution, because Constitution is the supreme law. That ensure legal certainty. Certainty why? Because it does not mean that who is the president and who like the order or not. When there is a valid order, you have to implement whether the president is in the position or he has been stepped down. So it ensures legal certainty. It does not mean that if the president is removed, then your order has no meaning. Your order has all meaning as implemented by the Supreme Court in Madison case. Chief Justice John Marshall said, a law repugnant to the Constitution is void, and thus Marbury is the cornerstone of Constitutionalism. So this is the end of this case, my dear friend. But now this is another case, Nixon. Very interesting case of 1974. It is basically the citation of this case is 418 United States 683 1974. The facts remain President Nixon refused to hand over the White House tape related to Watergate scandal, claiming that is executive provide. That means it is exclusive domain of his collection of evidence. The key issue, does the president have absolute privilege to withhold information? The ruling says the US Supreme Court ordered Nixon to produce the tape. No one is above the law. And that was in year 2015, Magna Carta. That also says no one is above the law. The king is subservient to the law. And again, Nixon case in 1974, you just see it starts from 1215. Now it is 1974. So this kind of tussle continues from time to time, from different country to country. That means the basic tussle remains in one way or other. The court says no person, not even the President of the United States, is completely above the law. Rule of law must prevail. And that is the beauty of constitutionalism. Now, having said that, now let us move to United Kingdom. As I already mentioned, United Kingdom does not have any written codified constitution, but it has the spirit. How it works? I believe that UK does not have constitution, but it has expressed very strong constitutionalism. So constitution is the base and constitution is its implementation. So it's a kind of twin sharing. But in United Kingdom, constitution is not there. However, constitution is very much robust and have shown its strength time to time. Let's see how. This is the case, as I told you, Miller case. There are two cases actually. In 2017 and 2019, we are taking the second case here. 2019, the facts were Prime Minister Boris Johnson advised the Queen to suspend or prorogue the UK Parliament for 5 weeks during Brexit debate, effectively silencing Parliament. If you remember, in 2019, Brexit issues were very prominently dealt in United Kingdom. There was so much tussle. So, considering that Parliament have lot of conflict on their standpoint, the then Prime Minister of United Kingdom suggested the Queen Elizabeth to suspend the Parliament. Parliament is supreme in United Kingdom. You always remember. Parliament is supreme to anything, even to the Constitution. Although Constitution is not written, but Parliament is supreme law and supreme in all aspects. The key issue in this case, R versus Prime Minister, was the prorogation was lawful or abuse of executive power. The Supreme Court, and you remember, earlier it was Hall of Lords, HL, but the Supreme Court of United Kingdom was established in year 2009. Again I repeat, earlier it was House of Lords, but in 2009 UK Supreme Court got in place, right? Now there is no House of Lords per se, although the building and other Westminster and everything is the same. However, things have changed in their working. And another point, they call not Chief Justice, they call President in the Supreme Court of United Kingdom. The UK Supreme Court held that prorogation was unlawful. That means the advice of the Prime Minister Boris Johnson was not legally tenable. It was observed by Lady Hell, the President of the UK Supreme Court. Quote, the courts have the responsibility to uphold the rule of law. The government is accountable to Parliament. Parliament is supreme, not the government. That's the beauty of the Constitution. Again, the Constitution got implemented. It got its existence loud and clear by the Supreme Court. Parliamentary sovereignty and accountability is utmost, despite codified Constitution. Now, this was the issue, or you can say various learnings from United Kingdom. Now let us move to India. I think Indian part, my dear friends, is slightly large because so many things had happened, and I have tried to give you a very brief but a very descriptive as well content on how law of constitutionalism developed in Indian ecosystem of law. Power of amendment of the Constitution. Basically, in our Constitution, if I say Article 368 deal with amendments in the Constitution. 368 article. There are a series of cases actually where there was tussle between Parliament and judiciary, and especially it precipitated in 1967 in Golaknath case. We'll discuss, but I will take you right from the first amendment, and particularly from 1951 when Sankari Prasad versus United States, the Supreme Court held that Parliament has power to amend fundamental right. So there was sweeping power given by the Supreme Court to Parliament to amend even the fundamental right. The same thing by and large was repeated in Sajjan Singh versus State of Rajasthan in 1965. That means up to around 15 years there was no conflict at all. And it was mentioned in Sajjan Singh that Parliament has unlimited power to amend any part of Constitution. This was Sajjan Singh case. Now, yes, Golaknath. Golaknath case is a watershed case in the history of jurisprudence in India, particularly the constitution conflict between Parliament and judiciary. Golaknath versus State of Punjab, 1967, AIR 1643. The facts of this case are like this. The petitioner challenged constitutional amendment that affect his fundamental right to property under Article 19 and 31 of the Constitution. The background of this case, my dear friends, was that Article 31 was fundamental right for right to property. That was being repealed, and the petitioner filed this case saying that the parliament does not have power to amend fundamental right. So this was the case. The Supreme Court, by thin margin, by 7-6, just imagine, it held that parliament cannot amend fundamental right. So this was the tussle. Earlier, Sankari Prasad, Sajjan Singh, up to 15-16 years of our independence and then our constitution got in place, there was no conflict. But now the Supreme Court says the parliament has no power to amend fundamental rights. So this was the start of tussle in a very big way. It impacted this tussle between parliament and judiciary. And why this tussle was there, and it has some logical reasoning also, because it hindered the intention of the parliament to bring laws, especially for agrarian reforms, and to distribute lands. You remember in those days, the lands were in the hands, and the large chunk of land particularly were in the hands of few landlords, the jamindar. And anti-jamindar laws were brought in. However, if you touch the fundamental right, particularly the right to property, then court came to rescue the landlords particularly, and the parliament felt that we are helpless and we cannot make laws to distribute resources for egalitarian society. That was the problem. Now the reaction, parliament actually to nullify the impact of Golaknath, they introduced 24th Amendment in 1971 to nullify Golaknath case. So remember Golaknath in 1967, and in 1971 to nullify Golaknath, 24th Constitutional Amendment Act was passed. Now after that, Keswanand Bharti is very, you can say, the glaring case of Indian jurisprudence. It is innovative to the extent that the doctrine of basic structure for amendment of the Constitution was formulated. What the case was? Let's see. As I told, this case was decided by our Honorable Supreme Court in 1973. There were 13 judges, and again the decision was from thin margin, 7-6 judge bench. Fact were, Keswanand Bharti, a religious head, he challenged Kerala's land reform laws under the Constitution. The main issue was whether Parliament has power to amend the Constitution was limited or it has unlimited power. Key issue was, can Parliament amend any part of the Constitution including fundamental right? Remember, Golaknath has said that Parliament has no right to amend fundamental right, but the Constitutional Amendment, 24th Constitutional Amendment in 1971 has nullified that. It brought back to the same scenario, but again the court says, the Supreme Court propounded basic structure, doctrine, and the court says, quote, Constitution is not what Parliament says it is. There are inherent features which cannot be abrogated. It was told by Chief Justice Sikri and others, majority decision, 7-6. Justice Sikri, the father of the former Supreme Court Judge A.K. Sikri, Arjun Kumar Sikri. And Justice Sikri was the first judge, my dear friends, who was elevated directly from bar to Supreme Court. That means he never served in any high court but directly elevated to Supreme Court. That was his legal acumen. He was a man of very highly recognized legal practice. This emphasized limited power of government, ensuring India as constitutional democracy, not a parliamentary dictatorship. Again I repeat, this case established India as constitutional democracy and not as parliamentary dictatorship. The student may remember these lines because they may be very useful for you to replicate in your answers in the examinations. Now let me talk about the doctrine of basic structure, particularly for amending the Constitution. It is judicial principle developed by the Supreme Court of India to uphold Constitution so that the core identity, underline, the core identity of the Constitution may not be changed or destroyed by amendment made by the Parliament under Article 368. So in another word, I can say that the doctrine of basic structure ensure that under the guise of Article 368, the Parliament can amend any part of the law or Constitution, but the tagline is that it cannot destroy the basic structure. What is basic structure? It has not explained. Over the period of time, the features or the ingredients have been discussed. We will also discuss here to greater extent. The tussle, it again fueled tussle between Parliament and judiciary. Parliament desire for wide amendment power. The Supreme Court, being the custodian of the Constitution, restrict Parliament power of the amendment. So Parliament want larger gambit of amending power. However, Supreme Court put limitation, and that is the constitutionalism actually. Supreme Court held Parliament can amend any part including fundamental rights, but this is the catch point, but they cannot destroy the doctrine of basic structure. You can amend any part, but you cannot touch, you cannot destroy, you cannot alter the basic structure. Now what is basic structure? Yes, this is basic structure. The key element of basic structure, the supremacy of the Constitution. You cannot bring anything above our Constitution or any place Constitution. Then rule of law. If Constitution is there, then only you can ensure rule of law. Separation of power. Then republic and democratic form of government, secular character, judicial review. This is, in my opinion, judicial review is the most critical part of doctrine of basic structure and particularly for ensuring constitutionalism. Then federal character, free and fair election, unity and integrity of India. My dear friends, these are the indicative ingredients. These are not an exhaustive list. But remember, the doctrine of basic structure is the innovation by Indian judiciary to ensure constitutionalism. So, basic structure is directly proportional to implement constitutionalism. I think this is the most critical and important contribution by India in the legal lexicon at the global landscape. However, the list is only indicative. Indeed, it is constitutionalism which is the basically essence of basic structure. I have already mentioned this point. Now, another point. After 7 years, Keswanand Bharti was decided in year 1973. Minerva Mill case, my dear friend, was decided in 1980. This was 5-judge bench. The fact were Minerva Mill Limited was a Sikh textile unit in Karnataka that was nationalized under the Sikh Textile Undertaking Act 1974. The power of Parliament to amend Constitution was challenged, especially certain provisions of 42nd Amendment. What happened after Keswanand Bharti? Like you remember Golaknath. Golaknath happened in 1967. In 1971, the Parliament brought the Constitution Amendment Act 24th, by which Golaknath was nullified. Likewise, by 42nd Amendment, the Parliament actually nullified Keswanand Bharti. And you will be surprised what were the ingredients of Constitutional Amendment 42nd. Section 4 of this Constitutional Amendment, it inserted clause 4 and 5 in Article 368, which actually says that no constitutional amendment could be questioned in any court or any ground. Just imagine. Basically, by way of 42nd Amendment, to nullify the impact of Keswanand Bharti, this amendment, particularly Section 4, has taken away the judicial review power from the judiciary if the matter is related to amendment. I hope you understand. I will repeat. If Parliament has amended any part of Constitution, then 42nd Amendment says that judiciary has no judicial review power. How it can be justified? It actually defeats the very essence of constitutionalism, right? Another section of 42nd Amendment was Section 55. It provides directive principle primacy over fundamental right under Article 31C, the property right concept. Actually, what was the reason? Reason was that government was thinking that directive principle which is related to development and to ensure social justice under Article 39A. So they says, or this particular amendment 42nd says under Section 5 that directive principle have priority over fundamental right. Although in my opinion or anybody's opinion, fundamental right have higher pedestal compared to directive principle, and that is why we have the writ system under Article 32 and 226 of the Indian Constitution. But this debate does not find place here because of time constraint, but this is very important. So I hope you understand these two critical areas why Amendment 42nd was very important and significant. So this part actually, the 42nd Minerva Mill case actually deal with 42nd Amendment of 1976, precisely speaking. It says that, or the court held that clause 4 and 5 in Article 368 are unconstitutional. Why? Because they were against constitutionalism. They actually abridge the right of the judiciary for judicial review. How can it be constitutionally valid? So it was declared constitutionally untenable. Since it destroys power of judicial review, which is integral part of basic structure, we have already discussed. Article 31C as amended is unconstitutional again, since it destroys harmony between fundamental right and directive principle. The significance of this Minerva Mill case is to strengthen the Keswanand Bharti principle of basic structure, and it reinforces judicial review as safeguard of democracy, and it is the integral part of constitutionalism. So I hope that you can understand that how beautifully the Indian judicial system particularly our Supreme Court, Honorable Supreme Court, how they have established the concept of doctrine of basic structure in order to ensure implementation of constitutionalism in our country. Now let us go for South Africa. We have already discussed about US, UK and India. So this is the fourth country, South Africa. South Africa has faced, my dear friends, lot of issues about apartheid. When we were student, we have seen Nelson Mandela means locked behind the bar for decades together. He spent his prime youth in jail, but ultimately, like our national father Mahatma Gandhi ji, Nelson Mandela also, devoted his life for the freedom of South Africa, and once the freedom was granted, then they have promulgated their constitution in 1996. This case is very important for constitutional point of view. Minister of Health versus Treatment Action Campaign of 2002. The facts were the South African government restricted use of antiretroviral drug to prevent mother-to-child HIV transmission. There are possibilities that if mother is suffering from HIV, the child in womb may also get HIV by this, and this medicine was actually curing. For certain regions, government banned it, restricted. The key issue, did this action violate the constitutional right to health care? The court held that the government restriction was unreasonable and unconstitutional. It was observed, quote, the state is obliged to take reasonable measures to progressively realize the right to health care. Justice Nagobo. It enforced justiciable socio-economic rights and supremacy of the Constitution. Again, the constitutionalism was placed. Now you see Australia. What is the scenario in Australian system? Australia Communist Party versus Commonwealth of 1951. Almost the same time when we got independence in 1950, and most of our important cases start appearing in 1951, almost at that same time. The fact was the Australian government passed the Communist Party Dissolution Act to ban Communist Party, citing issue of national security. On the basis of some flimsy ground of national security, they have banned the Communist Party by the ruling party at that point of time in 1951. The key issue was, could Parliament ban an organization without judicial trial or proper evidence to prove that they are anti-national or they are threat to national security? The key ruling was, it was told or it was established or the court observed, quote, the Constitution is a rule of law. Parliament cannot override it by mere declaration. It was said by Chief Justice Dixon of Australia. So now at the end, we have certain concluding remarks, or you can say the takeaway. The constitutionalism is a tool to actively enforce limit on government. So constitutionalism ensures limited power of the government so that it does not become authoritative or it may not violate the rights of the public. The judiciary across globe established constitutionalism is not abstract. It works through real disputes. You might have seen several cases. That's what I prefer to discuss this very vital judicial concept through case laws, because there you might be seeing law in action. Case laws are basically the illustration of case in the action. The judicial precedents inspire other jurisdictions for promoting constitutionalism. And my dear friends, at the end, I must say, this is my own observation, without constitutionalism, constitution is merely an empty vessel. So, with this, I think we have concluded, and I could transpire the message what I want to convey, particularly on how best constitution can play role in the society for the development, for growth of the people, for ensuring peace and tranquility, so that people may feel happy and everybody grow with time. With this, today it was 25th of our show, and you continuously support us. I sincerely request you to spare time to watch this channel and share it with your friends, and please subscribe it so that it could reach you well in time. Again, in the evening time, every day we have at 6 o'clock the real session, where in about 3 minutes we provide you very important information on various diverse topics. With this, once again, as I promised, in less than 1 hour, we conclude our talk.